Law Talk with Nick Maruchak. Thanks to MKI Legal, your trusted employment and family lawyers.
I fought the law and the law won. I fought the law and the law won.
Nick Maruchak joins us from MKI Legal. G'day, Nick. How are you?
G'day, Bowie. Great.
Yeah, good to see you. Is it legal to get out of an Uber in the middle of the road when it stops outside a stadium?
Well, I think that would infringe the road traffic regulations, which basically makes it illegal to hinder traffic. And so I think that one, if there's an obstruction, that potentially might be an infringement there.
All right, okay. If enforced.
Yes.
If enforced by the local male and female coppers who are there in great number. It's very much an interpretive thing, isn't it? 10 minutes past 10. If you'd like to ring Nick today, you can. 133 882. It's a talkback show, talkback station, so we'd love to hear from you. Give Nick a call soon. And a text from one of our listeners, Nick. Police called me today, asked me to come in for an interview. They have a few questions for me. I arranged a date and a time. They said if I didn't come in, they'd come to my workplace. So a little bit of a passive-aggressive threat there. I was informed the interview will be recorded, after which they'll decide on further action. My question is, what are my rights? Can I decline the recording? Can I decline the interview?
Yeah, so if it sounds like this person may potentially be investigated and he might be a potential accused person, so you have the right to silence. You don't have to, if you don't have to attend an interview, you can decline. You don't have to assist the police in any way to build their case against you. So that, and often, I'm not a criminal lawyer, but often one of the things we were taught very early on is the purpose of a police interview is only for their benefit. It's rare that it will be for your benefit. They're just, because they record it, you say something, and then later in court, they'll use it against you. So that one is a no. If you are a witness, though,
a no, you can decline?
You can decline if they're investigating you,
yes.
Right? If you're the subject of the investigation. There are certain things you have to give police, like your name and address and stuff like that. You have to give the basic information, but you don't do that. So he can decline there. If he's a witness, right, so if the charges are not against him and he's a witness, then look, you just have to make sure you don't hinder any police investigation, right? There's something called obstruction of justice, so don't do that.
Yep.
But the witness thing is, witnesses generally, my understanding is it's voluntary, right? The only time you can compel a witness, if police want to compel you, they can. What they'll do is they issue a summons, right? A court summons, a subpoena, then you'll attend. So that is something, but, I would just have a quick chat with a criminal lawyer about that as well, because you want to, and it's good that he did this text anonymously, because when it comes to criminal law, you don't want to say too much over the radio.
Yeah, no, too right. Thanks for your correspondence. If you'd like to ring Nick Maruchak, you can. 133 882 is the phone number. Have a chat to Nick on the phone. Then Nick can ask you further questions. You can interrogate. Nick can interrogate you, vice versa. 133 882 is the phone number. Is Sean there? Not just yet. So Sean's about to join us here on the show. 133 882 is the phone number. You can text in 0487 999 882. It's 12 and a half minutes past 10 o'clock. Nick Maruchak from MKI Legal has called through. No, not yet. So just waiting to get Sean on. So I guess we're checking some technicalities and legalities here. We'll take a break. Nick, we'll come back in just a moment. 13 minutes past 10. Back with more of Nick Maruchak after these. 16 past 10. Nick Maruchak's with us from MKI Legal. If you'd like to give him a call, you can. G'day, Sean.
Hey there, Nick. Hey, Simon.
Hey, mate.
Oh, look, a random one. I've just moved properties and I'm getting solar panels put on the house, and I thought I'd take advantage of the government subsidy as well. So I approached a company and they sent me a quotation, and they preempted what the government had initially promised, apparently. But they sent me the quotation. There was a section to click to proceed if you're happy with the quotation, which I did. They came and they've done the first part of the install, waiting till the 1st of July when the batteries, I think, are being released. But then yesterday they sent me a message saying, actually, the quote we sent you isn't valid now because the government have changed the goalposts and you need to pay $3,700 extra from what we quoted you.
Far out.
They said, or you can just leave the battery and not get it, and just pay for your... But they actually have sent me the initial quote was preempting the government first subsidy, and I think when the goalpost changed the other day, so they're sort of backtracking now, and they said, so I don't know what to do.
No, let's see what
they got clauses to get out of it, and they said you have as well, but yeah.
Sorry, could you, Sean, did they started the work?
Yeah, they've started already, and they've put the first part of the stuff. They haven't connected it yet, so the panels are actually up, and they're asking to come back on Friday to complete that part. And when that's done, they were going to come back and maybe in another 3 or 4 weeks' time after the 1st of July and install the battery. And
the battery is the one that's the issue here, right? Is that that's what's caused the price increase?
Yeah. They'd quoted with the first quote though did come with the solar power panels and the battery. And then they've come back and said, "Oh, look, we have to amend that quotation." Even though they've started the work, and they're coming back tomorrow, ironically, to finish off. But I've not paid 1 penny yet, but I've got all these panels on my roof not connected, waiting for the battery.
Okay, so this is this thing, right? So you have a look at the terms of the contract and see if there's any room in the contract for them to charge you more, right? See if the contract is subject to this government rebate.
Yes.
And see if they allow you to do that, right? If they do allow you to do that, if that's in the contract, then they may be able to rely on that. But there's something called unfair contract terms, right? So if there is this variation clause, this one-sided unfair price increase, and it doesn't give you a right to kind of terminate, that could be seen as an unfair contract term, right? So here, the question is, they've got this pricing, say if they have this price increase in the contract, do you want to just leave and cancel?
Yeah,
is that?
I see they've got the panels up there already, and I'm saying, oh, well, wait a minute, I did have alternative quotes, and they were a little bit cheaper. And I went with you guys just because of your reputation. But there is a temptation to come and take them all back. But I know I'll be left with holes in the roof, and and them labour intensive. I've not paid anything yet because they've been trying to do it, and then the rain has stopped them many times. And then this has happened in the meantime. So.
Yeah, so
I'm being a bit bitter because I do want the battery and I do want the panels, and I was happy with the first quotation. And to be honest, I'm sort of happy with the next, but I just think for them now to go, actually, it is going to be 3,700 extra.
Don't want to pay that bit.
I can give you a quick call, or my team can give you a quick call, Sean, and just give you a bit of tips. But I think you can negotiate this, right? And I think this is something that they probably should be resolved. Given that, given what's happened. So, it's either you push forward and say, take it all back, I want to cancel the contract, or you accept the panels without the battery. But I'll give you some further tips on I reckon, start the negotiation process and use the Australian consumer law.
We'll take it offline, Sean. Thanks, Nick. That's a nice offer. Didn't know you had a team. You and your team. How many's in your team? 100, 200?
10 lawyers, yeah. Sometimes I get people to help me out, so yeah.
I like it. Thanks, Sean. Good call. Very interesting. I wonder if anybody else has been caught up in that. And I'm not sure what part of the rebate rules have changed there, because that sounds a bit unpleasant. G'day, Frederick.
Yeah, good morning, Nick, and good morning, Simon. My question relates to a deceased estate. And the context is that there's, say, 4 commercial properties which have been specifically gifted to beneficiaries. However, one of the beneficiaries is a foreign resident. My question is, because it's specifically gifted in the will to a foreign beneficiary, can the executor elect to sell the property instead and give the proceeds to the foreign resident without all the other beneficiaries agreeing to the change?
Yep. So, first of all, there's usually terms in the will that says the executor has these powers to sometimes sell property and give the beneficiary the proceeds of the sale. So you just have to have a look if that term exists. If there isn't a term, there is this special provision in the Trustees Act, right? If you have a look at WA Trustees Act Section 30K, that lets a personal representative basically sell an asset and give the beneficiary their share, right? So what that process involves, say if the beneficiary doesn't agree to this, that section of the Trustees Act basically would require the executor to write to them to say this is what we want to do. And then if the beneficiary says, no, I don't want the sale proceeds, I want the actual property, they can go to the Supreme Court to get a court order. So there is an avenue for that if there isn't specific powers in the will. And I know it sounds like, Frederick, you've also emailed me, I think last week. I did get an email about this.
That's right.
So I have had a quick look at your matter. The other thing you have to really be aware of is the Foreign Investment Review Board. That actually prevents foreign people from getting property without permission, right? So in the past, if a property was gifted to a foreign resident under a will, it actually was exempt. But in the last couple of years, they've tightened that loophole. So there's no longer that loophole where you don't have to get approval. So if the foreign resident is going to get the actual property under the will, then you might have to go get approval from the Foreign Investment Review Board. The only time you won't need approval is if it transfers outside of a will, which is under the laws of intestacy, right, the automatic transition. So there's a few things going on there, but the answer to your question is generally the executor does have the power to do it. And especially if there are foreign residents there and if the beneficiary disagrees, then, the Supreme Court can make a decision. Does that...
Okay, because the information I've read online is that it doesn't require the executor can still gift the property, and the approval it can be done within 30 days of it transferring.
But I would recommend contact the Foreign Investment Review Board to make sure that they don't need approval, because if you get that wrong, there could be a fine there. So, yeah.
Thanks, Frederick. I hope that helps, mate. And I know you have been emailing Nick, so we'll keep us across that one if you will. Good day, Ron.
Oh, good morning, Simon. Good morning, Nick. How you going?
G'day, mate.
Yeah, look, a few weeks ago, I witnessed an assault at the front of my place to...
Ron, just move around a bit, mate. Your phone's dropping in and out.
Oh, sorry. Is that better?
Yeah, thank you.
A few weeks ago, I witnessed an assault at the front of my place to my partner's daughter's fiancé. The guy who committed the assault was charged with common assault and impeding breath. And it went to court in Armidale. He sought some time off to seek legal advice, and he got that. And it went back to court a couple of days ago. We rang to find out what the outcome of that was, whether he was going to go further with it to trial or anything like that. And the court said, we can't tell you anything. And I'd like to know what the situation is. We need to know what our next move is going to be.
You're a witness, right, in this?
Yes.
Yep. So has the police prosecutor been speaking to you? Because you should liaise with the police prosecutor.
Not at this stage. We said if it goes to trial, I'd probably be called to go to trial with them, because I made a witness statement.
Mm-hmm.
But apart from that, we haven't heard anything. When we rang the first time he went, when it was adjourned, they just said straight out, yep, it's been adjourned to June the 18th. But when we rang yesterday to find out what was happening further from that, they just suddenly said, we can't tell you.
Yeah.
We don't know what's going on.
Well, yeah, because they do publish, every day, the court publishes a list of all the cases there. So the police prosecutor is going to run the case. It's very normal for people to get adjournments for get legal advice. It can happen 2, 3, 4 times. This person's got to make a decision whether they're going to plead guilty or fight it. Then if he pleads not guilty and he's going to fight it, then it's going to be programmed to a trial. And that's when the police prosecutor will reach out to you and go, okay, these are the trial dates and we need you to come in. So what I suggest is just contact the prosecutor first, and then otherwise just keep an eye on the court list. It's published online, so that's what you do. And the prosecutor is in charge of running this. So they're the ones that should be communicating with you and if it's defended and goes to trial.
All right, well, thanks very much for that. It's just that we thought we'd told whether we'd be going to trial or what would happen yesterday, that's all. And they just don't want to tell us anymore.
Yeah, because it's basically that the accused has got to make a decision on whether they're going to plead guilty. And if they plead guilty, they're not going to need you, right? It's only if they plead not guilty and fight it. And that's when it's the prosecutor's job to contact you and go, because they have to prove the case. So if you're an important witness and they need you there, then they will get you on the stand. But if they can prove the case without you, then maybe they won't even contact you, and then it's just a matter of you doing the work to look at the list to find out when it is.
Thanks, Ron. Good luck, mate. Hope you get to find out and hear where that's all heading. G'day, Kevin.
Good morning. Two quick questions. One, if one person declares bankruptcy, is their spouse or if they're married or de facto, is the spouse included in that bankruptcy? And secondly, is it a commercial lawyer that would help giving advice with the purchasing of a business that's a subject to a bankruptcy?
Yeah, so the spouse is not automatically included. That the spouse is a different person. So no. What can sometimes happen though is it does get a little bit more complicated if you own a house with a bankrupt person, because that half share of the house would potentially fall into the bankrupt person's estate. But the other half of the house is the non-bankrupt spouse's ownership. In terms of the lawyer, I would say bankruptcy lawyer. They're the ones that can really give you someone that's got a lot of experience in the bankruptcy area. I don't know anyone off the top of my head, but that's how you would get help from there, because you want to make sure that if you're purchasing new property with a bankrupt spouse, you probably want to purchase the property in the name of the non-bankrupt spouse, because it could be you're going to be bankrupt for 3 years, and that's an asset that's claimable in the future. So you just want to be careful of that.
It's more of a case that it's for my brother. He's been approached by the person that's declared bankruptcy, and they're trying to get it so that his wife is still a director, but wants my brother to pay the administrator to buy the business. And I'm telling my brother, no, if you're buying it from the administrator as thing, you're taking 100%. And the last thing you want is to have any association with the person that made it bankrupt in the first place. Well, so I was just trying to work out whether they can even get on as director, whether she'd even have the funds to even contribute to the thing. But if it is split between the two, then but he can talk to a bankruptcy lawyer about purchasing it. He's not bankrupt, my brother, but he's looking to buy it.
Okay.
So I was trying to give him advice who to go to.
Okay, cool. Commercial lawyer then. Commercial lawyer that's got experience in insolvency. So what happens here is that obviously the business has gone under, and then an administrator's gone in, and they when a business goes under, there's a whole process that liquidators, administrators go through to recover the assets for the creditors. And one of the things they can do is sell the business, and that usually involves negotiating something called a deed of company arrangement. So go to a commercial lawyer that's got experience of dealing with insolvency. That's what I'd recommend if you're buying from a bankrupt or an insolvent.
Thanks, Kev. Good on you, mate. Thanks for calling in today. Nick, we've run out of time. Thank you so much for today. Thanks for moving your day around to accommodate our Leo Sayer interview. We really appreciate it. And you and I catch up. We'll talk about those new privacy laws next week, hey?
Sounds good. Thank you.
Good on you, mate. Nick Maruchak from MKI Legal.